friends. If this is your first time, welcome. This is Michigan Crime Time with Jess. Today we are in Detroit at the Detroit Detention Center. We have some high dollar cash bonds, like cash money only. So we got several cases. Let's get on over there and check out what they've got for us.
All right, this is case number 230-559-8001, People of the State of Michigan versus Techwan Edwards. Is Mr. Edwards there with you?
Yes, he's right here.
Yes,
Thank you. What's your name?
Techwan Edwards.
Thank you. All right, counsel.
Good morning, Your Honor. Erica Tucson on behalf of the people.
And for the record, Your Honor, Janice, the appearing on behalf of Mr. Techwan Edwards, who stands mute based on reading of the information after the plea of not guilty in Your Honor's behalf. Mr. Edwards has been advised of this right, Your Honor.
Thank you, counsel. The court notes formal reading has been waived. We'll enter a not guilty plea on Mr. Edwards' behalf, and I will hear your arguments as to bond. I don't know who wants to go first. All right, to the people.
Yes, Mr. Edwards, he has an extradition notice from the feds out of Missouri for delivery of synthetics, a Class C felony that was issued in August of 2020. He has an alias, James Pope. He has a conviction of unarmed robbery where he served a 4 to 15. He just got off parole in June of 2020. He also has a home invasion from 2015. Looks like it's a HIDTA. He also has some traffic warrants, one for failure to ID himself at an injury accident and failing to leave the scene of an accident. That was issued in February of 2023. In this particular case, he admits to having a weapon, that weapon being a .40 caliber with a laser sight, and it was turned on. He smashed into 2 vehicles after fleeing when a vehicle pulled up next to him and shot at him. As the officers approached the traffic accident, shots were fired from the vehicle. Civilians and officers both witnessed this, so the people are asking for a high cash bond given all the circumstances.
All right, thank you. Defense counsel.
In particular, considering extradition, Your Honor, we ask for nominal bond to be held regardless of bond court set. Mr. Edwards, 26 years old, Your Honor. The only height that was not shown the habitual offender Mr. Edwards is working at this time, Your Honor, but he does not have money to post his bond. He, as the court can see, is in the hospital, is in need of continued medical attention, having been a victim of a gunshot wound, Your Honor. So we're going to look for nominal bond, especially considering the fact that there's the extradition pending.
Thank you, counsel. That extradition having been out there since 2020, I'm going to set the bond that I think is appropriate to hold him at this time. I am hearing both indications of danger to the community and flight risk, failure to give the real name at a stop, that extradition being out there since 2020, having just been released from parole. I've got another, an unarmed robbery, which, you know, it's not armed, but I do consider that an assaultive, threatening type of offense. So I see both danger to the community and flight risk here. For that reason, I am setting bond in the amount of $500,000 cash, no surety.
Thank you.
The next court date will be in front of Judge Jefferson. Probable cause conference set for March 24th. Preliminary examination set for March 29th, March 29th. Mr. Edwards, you are not to purchase or possess any firearms or other dangerous weapons during the course of this bond. Thank you. Redetermination hearing, I'm sorry, will be Monday, the 20th in front of McConaughey.
Thank you.
All right.
So, I really didn't know. I mean, I heard, but I didn't. It was a mistake.
Am I good to?
Your bond is $500. Your bond is $500,000 cash. You have 3 upcoming court dates. One will be a bond redetermination hearing in front of Judge McConaughey on Monday, March 20th. He will reconsider the bond that I set here today. After that, you have a probable cause conference, March the 24th, and a preliminary examination scheduled for March the 29th. Both of those last two court dates will take place in front of Judge Jefferson.
Okay.
All right, thank you. Thank you. Okay, sir, what's your name at the DDC?
Demetrius Sparks.
All right, Mr. Sparks. You've got a couple of traffic misdemeanors where you miss court dates. When you missed your court dates, the judges assigned to those cases issued warrants and they set bonds. I'm going to set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are technically misdemeanors, for which the maximum possible penalty is up to 92 days in jail and or a $500 fine. First ticket is ticket number U190-75214, alleging July 24th of 2014 at an address on Michelle that you entered a vacant building without written permission from the owner. And then we've got 190-89114, alleging at an address on East Canfield that you were in that building, again, a vacant building without written permission from the owner. On both of those, you've got personal bonds. You're going to have the same court date, same judge, April the 13th in front of Judge Archer for pretrial. Then we'll go on to case number 230-559-1401. People of the state of Michigan versus Demetrius Sparks. Counsel.
Janet Stevenson, appearing on behalf of Demetrius Sparks, and interviewing the information not guilty, and on behalf of Mr. Sparks.
Thank you, counsel. Court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I will hear your argument as to bond.
And the court is aware the incident is alleged is from January 2020 to Mr. Sparks. No case history in this matter, Your Honor. Looks like a warrant. Sparks is 29 years old. This area for his entire life. He is working, Your Honor. He does have 8 children and his community is supporting. Mr. Sparks does not have money to pay his bond. He will continue to have no contact with the complainant to the location of the alleged incident. And Mr. Sparks asking the court to do some nominal bond considering the nature of the charge.
Thank you. So, I mean, the allegations here are that the defendant described as by a person known to him, his cousin apparently, says that he shot at her multiple times while she was in her vehicle. Police observed a bullet hole in the rear bumper of the vehicle after that incident was described to them, giving some credence to the allegation, perhaps. So I'm going to set a cash bond in this case. No one was hit. And, you know, I do find it interesting that we're talking about one bullet hole in a rear bumper, given the repeated firing that's described here at fairly close range. But I am going to set a cash bond. Certainly, Judge McConaughey will reevaluate this when it's in front of him on Monday. At this time, the bond is set at $500,000 cash. You are not to purchase or possess any firearms or other dangerous weapons during the course of this bond.
Cash money.
If you are somehow able to make this cash bond, you will be subject to a GPS tether with full home confinement. Next court date is going to be March 20th in front of Judge McConaughey for redetermination. After that, March 24th for probable cause conference and March 29th for preliminary examination. Both of those set in front of Judge Jefferson. You're not to purchase or possess any firearms or other dangerous weapons during the course of this bond, and you are not to have any contact or attempted contact with the complainant, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be considered a violation of the conditions of this bond. Thank you. Okay. We've got case number 230-559-5601. People of the state of Michigan versus William Curry Johns. Counsel.
Janet Stephen, appearing on behalf of Demetrius John, and delivery of information as a not guilty and trying to behalf of John, said by John.
Thank you, counsel. Court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I will hear your argument as to bond.
Thank you, Your Honor. Mr. John is 33 years old, Your Honor. He is not working at this time. He does have a mental health diagnosis, Your Honor. With after this file from our Techwan, he's taken to the hospital after his initial arrest. Mr. John.
Let's just do that now. DDC, would you please mark this file medical? Okay, go ahead, counsel.
And the incident is alleged, Your Honor, does have a little, it's about a month ago at this time. Never having been arraigned on this case, he doesn't have any case, it's just to be honest. He does live locally, Your Honor, with a brother and with his girlfriend. Again, he's 33 years old, he has 3 children in this community. We do have good contact information for Mr. John, Your Honor. He has struggled with homelessness in the past, and again, he does have a place to live at this time. Are asking the court, even considering very serious nature charges, Your Honor, we are asking the court to consider personal bond.
So not only are the charges serious, alleging that a person who knows they're not supposed to be in possession of a firearm is in possession of a firearm and then making threatening, movements towards another person with it. Also concerning is the way that this is alleged to have come about is that the person who had a firearm aimed at them with a laser attached to it when he opened the front door had gone to that door to respond to her friend who was in a domestic problem with the defendant. And that when she went there to help her friend, the door was then answered by defendant with a gun pointed in her face with a laser attached to it. That's even more concerning than the charges themselves, quite frankly. Because that indicates to me that not only is there a danger to this particular complainant, but there is danger to other members of the community present in this case. For that reason, I am setting bond at $150,000 cash in this case. There will be a bond review hearing in front of Judge McConico on March 20th. That's Monday. March 24th for probable cause conference and March 29th for preliminary examination. I'm sorry, yes, ma'am. Judge on those 2 last dates is going to be Judge Jefferson. All right, thank you. No contact with the complainant, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact will be considered a violation of the conditions of the bond. Thank you. All right, Mr. Wilder, 1 second, please. All right, you've got some traffic misdemeanor matters where you missed court dates. When you missed your court dates, the judge assigned to those cases issued warrants. They set bonds. I'm going to set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on these tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. The ticket is ticket number P1261-260, alleging October 11th of 2021 at East Davison and Mound that you drove while your license was invalid. Then I've got ticket number P1357-500, alleging June 1st of 2022 at Forest and Field that you drove without a valid license. As I said, on both of these, you do have a personal bond. You're going to be in front of Judge Taylor on these on April the 14th, 2023. Now we'll go to case number 220-603-7301, People of the State of Michigan versus David Wilder, counsel.
Stephen, appearing on behalf of David Wilder, who has been laser reading the information as he is not guilty and tries to have Mr. Wilder identified his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf, and I will hear your argument as to bond.
Mr. Wilder is 28 years old, Your Honor. He is working at this time. He does not have any money to take the bond. He would have an alternate residence if that would be the order. Of course, we would have no contact with the complainant. That is the matter, as the court does know, is over a year old at this time. So that Mr. Wilder can get back to work. Charges. If you have no objections, driving restrictions, we had to file out. But in order to let Mr. Wilder get back to work, we're asking the court to release him on personal bond again. We're looking at, allegations at this point, very, very, very serious in nature, but over a year old.
Thank you. There is an assaultive charge of domestic violence alleged here. It would be the second conviction if he's convicted of this one, which is quite frankly, pretty likely as troopers observed him dragging his wife across the street. According to this investigator's report. I would suggest that you remain silent right now, sir, as your attorney is doing the same. Perhaps you want to tell me that it's not your wife. I don't know, but you're charged with domestic violence, so a significant other or resident of the household. Some type of domestic relationship. They allege that you were observed dragging this person across the street. More concerning. More concerning.
May I, Your Honor?
In one moment. More concerning, I now have a third OWI charged here. The first one having been charged. Let's just see. A conviction having been secured for OWI in 2018. Looking for the other. 2019. So I've got a 2018 OWI conviction. I've got a 2019 OWI conviction. Now I've got a charge of operating while intoxicated. And not only operating while intoxicated, but operating the vehicle while he's intoxicated with an occupant in the vehicle less than 16 years of age. In this case, that being looks like a 7-month-old child in the car.
So, Your Honor, if I may.
Go ahead.
Mr. Wilder, maybe you didn't hear me, this is counsel. We have indicated to the court that we're pleading you not guilty, sir, on each of those charges, okay? So at this time, Mr. Wilder, I know that counsel told you before, but I'm gonna just remind you that everything that you're saying right now is being monitored and would be used against you. So we're asking you to exercise your right. Protect yourself from self-incrimination. Don't say anything right now,
I
okay?
understand that, but I was trying to let her know that I wasn't the drunk one. I'm not the drunk one. I was called by a bar to come get my wife. I understand. I'm trying to let the judge understand my side of the story. I was called that night by a bar to come pick up my wife because she was drunk. And that's why I was pulling her back into the car. Can I explain? I understand. I'm trying to I understand what you're saying. I know anything I say will be used. I'm happy this can be used with me because I was called that night to save my wife. She was intoxicated, very drunk that night. I came, she jumped out the car again after I picked her up from the bar that was.
She was drunk that night. You're right. She was drunk that night. They tested her. She had a 0.23. They tested you too. You had a 0.13. So she wasn't the only one drunk that night. She doesn't have a prior conviction for domestic violence. She doesn't have 2 prior convictions for operating while intoxicated. If a bar calls you and says your wife is drunk, the answer is not when you're drunk to stick your 7-month-old in the car and go get her.
So, Mr. Wilder, we're just not talking more right now, please. Thank you, sir.
If there wasn't drinking involved, probably better judgment would have been used about what to do in that situation. But at this point, given the priors, given the description here, I understand now the dragging across the street. Okay, he was trying to get her out of the bar. Again.
I was trying to get her into the car. She jumped back out the car. That's what happened.
Okay.
And then the police had seen.
Okay, sir, your counsel has advised you to stop talking. You are making admissions right now. You are making admissions about your behavior in this case, which I can almost guarantee you will be used against you because they are admissions on a record. I'm only setting your bond today. I'm not determining your guilt. I'm determining whether or not I believe you are dangerous to those in the community right now. The fact that you repeatedly get in a car and drive while intoxicated, according to this report, causes me to believe you are dangerous, that you have bad judgment, that puts the community at risk. It's $150,000 cash. The next hearing will be on Monday in front of Judge McConico, and he'll take a look at this bond and see if he thinks it's too high or too low. After that, March 24th for probable cause conference, March 31st for preliminary examination. If you're able to make my $150,000 cash bond, there is to be no drinking during the course of the bond, and there is to be no driving during the course of the bond. And as I said, you will have a redetermination in front of Judge McConico on March 20th, which is Monday. All right?
The judge for the 20.
Sabri,
Your Honor.
Judge Sabri for the last two. All right.
Thank you very much, Your Honor.
Sir, I am going to now stop you for your own good. I've made a determination about the bond. Another judge will look at the bond on Monday. Okay, you're going to have counsel again who will talk to you about what's good and not good to save the court. But I'm going to go ahead and remove you at this time. The bond has been set, court dates given, reasons put on the record, right? You will be in front of Judge McConico on Monday. Good luck to you.
Welcome. This is Michigan Crime Time with Jess. Today we are actually back in Detroit at the Detroit Detention Center. This is St. Patrick's Day, so there's a little bit of craziness going on. Our first case actually is a federal hold, so that's a pretty big one. What? I don't like this. I do not like this. Welcome back, friends. And if this is your first time, this is Michigan Crime Time. Oh my God! That's it. I'm not doing individual ones.